The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon, everyone, and welcome to this afternoon session of the North Carolina Court of Appeals. This is a remote session. I'm Judge Richard Dietz. I'm joined today by my colleagues, Judge John Tyson and Judge Hunter Murphy. And the first case, we have two cases for oral argument this afternoon. The first is number 2024, State v. Hemingway. And I understand the appellant has reserved 5 minutes for rebuttal. So with that, we'll hear from the appellant.
Good morning, Your Honors. May it please the court. My name is Jason Yoder, and I'm here today representing Gerald Lamont Hemingway on his direct appeal of the judgment revoking his probation out of Columbus County. This case presents two issues, I think. First, did the state present competent evidence that Mr. Hemingway sold or possessed cocaine on 12 March or 13 March 2018, where the state presented no competent evidence that the white powdery substance or the 3 rocks seized from the house were actually narcotics or any other kind of illegal substance? The second question in this case is whether the trial court violated Mr. Hemingway's due process right to confrontation when it refused to allow the defendant to cross-examine the paid informant, whose testimony formed almost the entire basis for the revocation. And I think if this court agrees with Mr. Hemingway on the first issue as to the competent evidence, it would not need to reach the constitutional question of the confrontation clause issue. There was a third issue that was raised in briefs. It regarded the positive test for cocaine and whether the trial court could have revoked for that. And I do believe in the state's brief, they conceded that it would have been error to revoke probation for a positive test of cocaine, but they claimed that that was probably a clerical error. So I'll focus first on the competent evidence issue. The evidence at this trial showed 3 distinct events. There were purportedly 2 undercover purchases on 12 March 2018 with a paid informant. We don't know very much about this informant because Mr. Hemingway was never able to cross-examine or confront this person. And the officer in this case didn't know very much about the informant either. He didn't know her criminal record, whether she had any criminal records. All he knew was that she was paid to get evidence against Mr. Hemingway. And we would argue that obviously a paid informant of this kind would be extremely unreliable and confrontation would be a necessity. But what she did apparently tell the officer was that she bought white powdery substance at the first buy. That white powdery substance was never identified in court by anybody. There were no field tests conducted. There was no chemical analysis submitted. And there was no testimony that Mr. Hemingway ever admitted to the identity of that substance. There were undercover buy the same day. And there was also no evidence submitted as to what that was. That was also apparently a powder, quote unquote. And the officer then read part of his police report saying that it was powder and crack. And then the third incident was the search of the house. The house search yielded a small baggie of marijuana and 3 white rocks. Those rocks were also never identified, and there was no chemical analysis ever submitted to show what those rocks were. So at the end of the day,
before you move on, I just want to ask about the marijuana. And if I'm correct, the allegations that are alleged in the probation violation reports and were found, none of those actually related to the marijuana, correct? Those actually found by the trial court judge?
Yes, I believe the trial court made 3 specific findings in this case. He found 3 violations in essence. One, that Mr. Hemingway had sold cocaine. He found a second violation that Mr. Hemingway had possessed cocaine. And I believe if you look at the violation reports and the evidence, you'll see that the sale was alleged to have occurred on the 12th, and the possessive offense was alleged to be on the 13th. And then the
In a
third.
criminal case, you would need the chemical analysis.
That's
Is
right.
case law that says we need that those that precedent that comes from criminal prosecutions applies to the probation revocation hearing where we have these lesser standards.
Well, I think here we're looking at in Osborne. Actually, the North Carolina Supreme Court said you don't have to have chemical analysis if there's other evidence in the record to support the identity of the substance. So in Osborne, the defendant, I think, admitted that they had heroin. And so because the defendant had admitted it, there was substantive evidence. And the substantial evidence inquiry would be for a motion to dismiss is almost the same as the competent evidence inquiry for a probation revocation.
Well, my question is, why couldn't a trial court infer that this must be drugs in a way that you couldn't do that at a criminal trial because of all the other evidence about the circumstances in which these substances were found? So you don't need to have the other indicators that you would need even after Osborne, which is typically chemical analysis, although there can be these other things like an admission from the defendant. Why shouldn't we hold that because we have all these lower standards at this hearing in terms of evidence and things like that, that the trial court can just, based on the record that's here, infer that and make that finding?
Well, I think probation cases, they don't have a lower standard of evidence, they have a lower standard of proof. So the distinction is, in a criminal trial, the state is required to prove something beyond a reasonable doubt. But in a probation revocation, it's only to the judge's reasonable satisfaction. But that doesn't mean that the state can prove an offense without showing any evidence of an element. That would do away with due process requirements altogether. What we're looking at here is the absolute minimum level of proof in terms of evidentiary that the state has to make to get a probation revocation.
Why wouldn't it be enough that we have his admission to having at least touched cocaine, a failed drug test, and a white powdery substance? Why isn't that enough circumstantial evidence for this lower burden of proof to satisfy what the state needed to present for the judge to be reasonably satisfied?
Well, the allegation that he tested positive for cocaine was on a totally different date. I believe that was in April of that year. So it's not connected temporally to the allegations in this particular offense or these later offense charges. So I would argue that you can't import something from a month earlier onto an allegation of an evidentiary claim that happens a month later. That's the first reason. But the second reason is that actually, if you look at the findings of fact here, the trial judge specifically found he did not possess cocaine on that date. So there was an allegation, a criminal allegation, that he essentially possessed cocaine on that date by taking cocaine, and the judge dismissed that particular violation. So that finding of fact is binding on this court at this point in terms of an evidentiary finding. It appears as though the court merely concluded that he tested positive, but the state failed to prove he ever possessed cocaine on that date. And he did testify that he touched it, but there was no evidence of how he touched it, whether it was intentional, whether it was accidental. And so we would just argue that you can't show that a person had used cocaine at a previous date and infer that they used it later. And that would be something like 404B evidence.
What about adding in the fact that there's an informant testifying about having bought what the informant believes to be the cocaine? I mean, isn't that something that here, as opposed to in a criminal trial, a judge could look at and say, well, that's just enough then to make the inference that this is cocaine?
Well, Your Honor, if you would conclude that that was enough to get over the sufficiency basis for revocation, and then our alternative claim would be that there was a confrontation violation here as to that particular element. And I think if you look at some of the cases from outside of North Carolina, you'll see that they don't sustain revocations based on the testimony of unidentified informants without cross-examination. And I did file a memorandum of additional authority. I know they're not binding on this court, but they are instructive as to how far this court has sort of drifted away from the due process requirements of Gagnon and Scarpelli. And I think if you look at a case like United States versus Banks, which is a Fourth Circuit case, it was an unpublished Fourth Circuit case, so obviously it's not binding even on the Fourth Circuit, but it demonstrates how due process requires confrontation. Yes, it is different than a criminal confrontation right. But confrontation is
your friend from the state. I'm sorry, Council. This is a little hard with the back and forth on the remote video, I know. I think your friend for the state is going to argue that before we even get there and you start making this argument that we should be using a test like this balancing test federal courts have applied or other states have adopted similar tests, you've got this problem, which is a recently decided case from this court that essentially says that unlike the Sixth Amendment Confrontation Clause right, this due process confrontation, and I think you'll concede this is not a Sixth Amendment case, right? I think I heard you concede that.
Yes, it is a 15th Amendment due process confrontation right. Right,
and we've said that if you want to, so it's almost like it's the wording here matters, that it's not the right to be confronted by the accuser or some witness. It's if you want this right, you may have it, but you have to ask for it. And the state's going to argue that didn't happen here because your client never subpoenaed this person to appear or took any other steps, and that when that happens, it's a waiver. So what do we do with that case law?
Well, I think for one, I mean, I obviously argued in my brief that Jones was absolutely wrong. And because it shifts the burden on the defendant to call adverse witnesses against himself. And that is just totally contrary to due process itself. But also, if you look at the facts of Jones, I think you can easily distinguish it. First of all, I don't think Jones even involved a confrontation violation because the defendant in Jones actually did confront the officer in a prior hearing. And so there wasn't actually a confrontation violation at all. There had previously been confrontation on the exact issue that came up with the revocation. So that's one reason that Jones doesn't apply. Obviously, in Jones, the defendant also knew the identity of the witness prior to the hearing because they had previously cross-examined the exact same witness. That's also not a case in Mr. Hemingway's case. Mr. Hemingway, there's no pretrial discovery available in a case like this to know, would be unaware because there was no prior opportunity. So the Terry case and the Jones case both involve cases where the defendant would have known of the identity of the witness in advance. In Jones, they knew about the officer because they actually cross-examined the officer previously. And in Terry, it was the defendant herself who created the witness by making an argument that she was unable to attend these Saturday classes. So in both of those cases, I think that's very distinguishable. And I'd also,
Mr. Yoder, in our criminal procedure, is there any right to discovery in a probation case?
As far as I understand, I have not seen that. There's a codification of a right to discovery. There was not a witness list, for instance, in this case, in the record that I saw. That is, sometimes you see witness lists in criminal trials submitted by the different parties. It's not always the case. But I do not know of any record here that or discovery requirement for probation cases. They're very informal, as you can sometimes see. It often leads
well, there's not a requirement. Can you point us to any cases where there's actually ever been shown a right to discovery in one of these outside of using regular subpoena process? Has there ever been a case where we've held that a defendant was entitled to discovery from the state in a probation matter?
Your Honor, I do not know the answer to that question. I could look and do research on that and follow up after this, but I don't know the answer to that right now.
And before we move too far on from Jones or dive into specifics of Jones, with Jones, is your argument that Jones was decided incorrectly, or is your argument that portions of Jones should be considered to be dicta versus the holding of the case, which obviously has a big impact on what we can do with a case. Obviously, if it's dicta, it's just dicta. But if it's the holding and your position is it's wrong, in re civil penalty, even if we think it might be wrong, we can't do anything about that. So what is your position on Jones and those issues in Jones?
Well, I would say that I think a lot of the language in Jones is dicta. So there's just a lot of commentary in Jones that's not cited to any previous authority. For instance, in Jones, there's a statement that the defendant failed to ask for the good cause finding. But the Jones court never cited any authority for that requirement. And it appears as though, if you look at the decision, it had actually already concluded this was like an affidavit or some other kind of document that didn't involve the confrontation violation. So I would argue that that aspect of it was dicta. And I think also the part of Terry about the witness having to call the professor against herself essentially was also dicta. But also harmless in Terry, because obviously the defendant in Terry ultimately not only admitted violating probation, but then later admitted she lied about not being able to, fulfill the requirements of probation.
And while we're talking about the underlying, before we really transition into some more of the confrontation issues, while we're talking about the underlying as presented and how they match up to a crime, I'm looking at record page 24, finding 3A. Says in paragraph 3 of the violation report or notice dated March 20th, 2018. That's the finding he makes. In that violation report, unless I just have my record mislabeled, when I look at record page 16, paragraph 3, which is that report, the very last allegation there of criminal conduct is sell or deliver counterfeit controlled substance, possession with intent to sell or deliver counterfeit controlled substance. Even without a test or anything else like that, or identification of this as cocaine, would it have been fine that the trial court found that he committed at least one of these crimes? It's either he is possessing cocaine or he's possessing counterfeit cocaine, and that would satisfy the white powdery substance would back up either of those two alternatives. Would that be a proper way to look at it? I'm sure you don't want to say it is, but tell me why I shouldn't look at it like that. Was probably the better question.
Well, the court in this case did not find that it was a counterfeit substance. And of course, showing that it's a counterfeit substance would have also required some kind of evidence that it was not, in fact, what it was purported to be. And the only record evidence we have that it might have been what's purported to be is the one purported statement by Vanita Brady that she bought white powdery substance and crack. And that would have been, we allege, within our confrontation violation argument. Other than that, there's just no substantial or competent evidence to support the identification of these substances. I admit.
No, go ahead, finish your thought. I'm sorry.
And what I also point out, and this is a problem sometimes with probation cases, is that the violation reports are written in a way where they put a lot of violations in one paragraph. But if you read the ultimate findings that were made here by the trial court, at the hearing, you see it's extremely limited. They found 3 violations, and while they included, that they found this paragraph, they did not find each one of these violations that are contained within the 3rd paragraph on page 16 of the record. I think that's clear from the hearing testimony itself.
I would agree with you as to the language that the trial court chooses to use. But have we ever held, or Supreme Court ever held, in a probation case that the oral findings are going to control over the written finding? Because the written finding to me is clear that it finds all of paragraph 3. And granted that the oral findings don't include that. So are you aware of any case that says we should be paying attention to one or the other?
Well, I would argue that they're not contradictory. I think that the judgment revoking probation doesn't necessarily mean they found every sub-allegation within that paragraph. It merely means that they found that there was a violation of 15A 1343B1, commit no criminal offense in that jurisdiction. But I don't think that necessarily incorporates every single one of these separate offenses that are listed below, of which there's like 6 or 7. So I don't actually agree that they're contradictory or that the judgment revoking probation necessarily incorporates all those by reference.
So I want to circle back to Jones, because I think in addition to the holding that we talked about, this idea that if you don't try to subpoena the witness or make some effort to have that witness come to the hearing, then you waived your confrontation clause right, at least the due process one. But I think another argument we're going to hear from your friend for the state is that another thing Jones said is that you have to specifically ask the trial court, make the good cause finding, the one that came from the U.S. Supreme Court, and that we took the exact words the U.S. Supreme Court used and put them in our statute. And it's this, the court has to make this good cause finding, and then that gets you out of the confrontation clause. The state says you've got to ask for that, and it doesn't appear in this record that counsel asked for that. So what do we do? What do we make of that argument?
Well, I think that what you would look to is the Morgan case from the North Carolina Supreme Court from just a year ago. I think it was 2019. The state made the same argument in Morgan that the court didn't have to make a good cause finding for revoking probation after probation had expired. They essentially made that same finding, the same argument, that if you didn't ask for that, or there was a waiver there, or that the court didn't have to make it at all. But if you look at Morgan actually cites Coltrane specifically for the premise that the trial court has to make that finding. The same finding that it also said you have to make in Morgan and Bryant. The language of the two statutes is identical. And to say that you have to request a good cause finding for confrontation would be incoherent if all of the other case law from North Carolina said that findings were mandatory. And I also think it also violates your due process right to have a written record upon which to appeal. If the defendant had waived this good cause by failing to ask for it, that is a very slippery slope. Next thing you might say that we waived the right to a jury verdict beyond a reasonable doubt, or a guilty verdict because the defendant failed to specifically request it. But we wouldn't find that. These are findings that are mandatory, and they're required because without them, you can't have appellate review. You don't know what good cause was and how to measure that against the confrontation right.
Mr. Yoder, I have a question.
Yes.
The testimony of Lieutenant Thompson, control purchase, the marked bills, the recovery of the marijuana, he was subject to cross-examination. Is that correct?
Yes, he was subject to cross-examination, but you can see the limits of what you get by cross-examining somebody who only gets third-hand information. He didn't know almost anything about the identity, or he knew the identity, the name of the informant, but he couldn't tell anything about her, whether she had a criminal record, whether she knew anything about cocaine or crack, whether she was a drug user. We're talking about a person who had extremely limited knowledge of the witness. And for that reason, being able to confront the officer was inadequate because it didn't really get to the heart of this question, which is, was that informant reliable? Was that person who was paid by the state to testify against Mr. Hemingway reliable?
Well, he is paid his salary as a sheriff's department lieutenant. He wasn't paid to testify. Is that a more fair characterization of his testimony?
Well, yeah, of course he's paid, but this informant was specifically paid to go collect evidence against Mr. Hemingway. I'm talking about the informant.
Okay, you're not talking about Lieutenant Thompson then?
No, that's part of his job, is to testify in court, and it's not impeaching that he's paid for that, but it's certainly impeaching that a person would be paid to inform against another individual. If you look at the Innocence Project, 1 in 5 cases involves a paid jailhouse snitch. So these are notoriously unreliable individuals.
Well, wouldn't the trial court as a superior court judge understand that inherent lack of reliability and still find that they're reasonably satisfied by it? Why would confrontation have been necessary for the judge to understand the inherent lack of reliability of this confidential informant?
Well, the confrontation goes directly to the defendant's due process rights in total, and they can't. And you're trying to applying a harmless error to it, and of course, constitutional violations are subject to harmless error review. But here, the substance of the allegation came from this informant, and without this informant's testimony to the officer, I don't think that there was enough evidence that the state could prove the violation here. The constitutional violation was harmless beyond a reasonable doubt, which is what would be required for the burden of proof on appeal here. I see that I do have less than 5 minutes left, and I would like to reserve that for my rebuttal. If you have any more questions, I can answer them now or on rebuttal.
Thank you.
All right, thank you, counsel. Your remaining time is reserved for rebuttal, and we'll hear from the state.
Thank you.
Good afternoon, Your Honors. Counsel, may it please the court. I am Narcissa Woods, Assistant Attorney General, and I represent the state of North Carolina in this action. Our U.S. Supreme Court and North Carolina courts have long recognized, that probation revocation hearings are not criminal prosecutions, but the court is not bound by strict rules of evidence, and that statements that are relevant for determining whether a defendant has violated a valid condition of his probation, such as hearsay, are admissible. And lastly, that allegations of violations of probation are not required to be proven beyond a reasonable doubt. Here, the state would argue, as to the first argument in the briefs, that the trial court did not violate defendant's right to confrontation. The transcript clearly shows that when defense counsel raised the objection of confrontation, the trial court allowed counsel to explain and then responded with 3 comments. 1, that this was hearsay evidence. 2, that the court was relying on State v. Murchison. And 3, the court noted the nature of the proceedings and then overruled defendant's objection on confrontation grounds. So the state's contention would be that the trial court, at least it could be inferred that the trial court did find good cause not to allow the confrontation of the confidential informant by those comments made by the trial court.
Ms. Wood, let me ask you a question. If it had turned out that the white powder here was actually baby powder, would that have made a difference?
Your Honor, the competent evidence presented by the state, as taken as a whole, was sufficient in this case to satisfy the trial court in its discretion, sound discretion. The identity of the powder or the crack was in the statement made by the confidential informant, with all the precautions and procedure that the law enforcement had taken to meet with the informant, give her money or bills whose serial number had been recorded, searching her body and her vehicle, ensuring that she had no drugs on her person or nothing on her person. The state would contend that all put together the state presented competent evidence at the probation revocation hearing. There is no requirement that the state prove beyond a reasonable doubt the evidence, what they're presenting. The standard in a probation revocation hearing, as recognized by our courts, is whether the state presented competent evidence. We would argue that it did.
But you would
Let me
agree.
ask you this: do you agree that the fact that the defendant had cocaine on his person is unrelated to the events of the possession?
Whether the defendant had cocaine on his person on what day?
Well, the day of the hot test that he had, it's like 30 days prior. So do you agree with defense counsel that finding does not support possession of the cocaine?
Well, that finding by the trial court, the trial court said that he
Tested positive.
that he tested positive. That in and of itself was a violation of a valid condition of probation that he not, and the trial court said possess or consume. And so we would argue that it was evidence that he consumed and violated his probation that way.
But that would have not been sufficient to revoke him. Do you agree with that?
Yes, Your Honor, under the Justice Reinvestment Act, that is testing positive for cocaine is not a probation revocable violation.
Had the trial court found the marijuana that was recovered, would that have been sufficient to revoke him?
Without identification of the marijuana, just a visual?
Well, I think it's a little different to identify marijuana than it is a white powdery substance.
Correct, Your Honor. We have case law that says a visual identification of marijuana by an officer. That's right. Yes, I suppose that would have made a difference. I don't know why exactly what went into the trial court's decision to dismiss that, but that's what we have.
Well, Mr. Yoder is concerned that we have basically stripped any meaning of due process in these probation hearings by allowing hearsay testimony and written testimony, that basically the burden on the state has become too low to comport with due process.
Well, in this particular case, we have, for example, comparing this case to Coltrane, where there was just, you can see that the facts of this case is very different. Here we have, first of all, there's no complaint from the defendant as to, how the trial court handled the probation hearing as a whole. Defendant was afforded the opportunity to and was represented by counsel. This case is very different from cases where there is no opportunity to present evidence or to present, given to the defendant to present why they should not be found to have violated or willfully or without lawful excuse violated their probation. But here we have a revocation hearing. We have defendant is represented by counsel. Defendant raises the objection. The trial court, in its discretion, disagreed with the characterization of the hearsay evidence as a confrontation issue. The trial court explained and provided its reasons. And so in this case, with due respect to counsel's argument about other cases.
So the statute says, and the statute is designed to comply with U.S. Supreme Court precedent, and it says, unless the trial court finds a good cause. And so when you look at what the court was considering, it isn't legal issues related to that confrontation clause precedent. So, we're searching for some indication that shows that the trial court thought about good cause and made some finding, and we're not, or at least I'm not seeing it in the record. So is the state's argument that we can just infer that in any case where the court overruled an objection based on the confrontation clause?
Your Honor, when we compare this statute to the statute being looked at by the Supreme Court in Morgan and Bryant, for example, that statute required the trial court to make a finding of fact, whether the state had made reasonable efforts to hold the revocation hearing prior to the expiration of defendant's probation period. This is a little different here. It's not necessarily the trial court finding, okay, on such and such a date, the state, filed their intent to proceed with the clerk or something that occurred before. It's asking the good cause finding is asking in this statute, it asks the trial court to make the determination based on the arguments being presented then and there. And so I would contend that there's a distinction between the state is not, we concede that the trial court is required to find good cause. This trial court did give an explanation there's no guidance for the trial court to say exactly how much good cause is enough good cause. And so I think that it could be inferred that this trial court attempted to comply with the statute and did comply with the statute. It is our contention that the trial court did comply with the statute. This statement by the confidential informant is hearsay. It falls squarely within the hearsay definition, and it is not just hearsay, though. It is also relevant to whether defendant sold drugs while on probation. That he sold it, to the confidential informant we disagree with what counsel is saying, that the confidential informant was paid to testify against the defendant. The defendant sold drugs to a confidential informant. The defendant did that, and the trial court was sufficiently satisfied based on the totality of the evidence, which we would argue that the state presented competent evidence to show that defendant did violate the condition of his probation, that he not commit new crimes.
But I think that's what I understood the argument your friend for the defendant is making, is that the hearsay analysis is different from whatever good cause analysis needs to occur in this confrontation clause analysis. It needs to be something that more closely resembles like the balancing test that we see the federal courts apply, many of the federal circuits that we see in other states, and that what was going on here with the trial court's consideration of hearsay factor just isn't enough, because what you're supposed to be getting at is the reason why the state can't bring in this witness so that the defendant can confront the witness, and maybe that there's very good reasons for that. The court just has to enunciate that. There has to be a finding of here's the good cause, and that didn't happen. And so, what's your response to that? Is your position just that thinking about it in terms of hearsay is going to be enough in these cases?
That is our position. However, if this court, goes down that line of thinking, is that I'm sorry, Your Honor. So if you want to say that the trial court had to do something more, where that trial court was sitting at that time, they didn't have that guidance or that instruction. And so what they had was Murchison, and they had the statute itself that says hearsay is admissible. And the trial court disagreed that this was a confrontation issue. So, you know, if more needs to be done, you know, given that the state presented competent evidence in this case, and there was no excuse given by the defendant, the trial court in its discretion, I think, properly, you know, found that the evidence was sufficient.
What can you point to in the transcript here that tells me, other than the informant's statement of one of the bags containing crack, what else do you have that points to any showing that this was actually cocaine?
The substance was, well, the trial court did not allow the submission of the lab report. So we don't have anything on the record to show that the substance was a you know, crack or cocaine on the.
So would you concede the state's only evidence of cocaine is the one statement calling it crack by the informant that did not testify?
Before the execution of the search warrant, yes, that's what's on the record. And you know, the after the execution of the search warrant, then again we have, you know, the seizure of 3 off-white rocks that, as described in the record.
You find 3 off-white rocks sitting in my 10-year-old's bedroom. I mean, that doesn't mean anything.
Yeah.
In terms of positioning that as a controlled substance. So is there anything even after the search warrant that points to this being a controlled substance? I'm basically saying, in these 80 pages, can you point me to anything other than this one statement by a non-testifying witness as to crack that would satisfy the state's burden here?
Well, again, the state's burden is to show competent evidence that defendant violated his probation by committing new crimes. The state did not have to prove that he committed the offense. This was not a trial or a criminal prosecution. The state had to prove, based on competent evidence, that defendant had violated his probation. We don't have, as I said, the trial court did not allow the lab report to be submitted into evidence.
Okay, I'm looking at record page 24. This is what I was discussing with defense counsel, that it includes paragraph 3 in the March 20th violation report. Do you agree with defense counsel that all we should be considering for those findings of fact are the oral findings made? Or is the state suggesting that we should be looking at all of paragraph 3?
Well, that, as to the written findings, Your Honor, that is what it says. In the findings number 3, the conditions violated and facts of each violation are set forth in paragraph 3. To me, that would indicate it's the entire paragraph.
Do you have any case law that suggests that we should pay more attention to the written finding versus the oral finding?
I don't have a case that I can cite, Your Honors. I can certainly research that if you'd like me to.
I mean, I can tell you, I don't have it laying around, but that is the law. What Judge Murphy just suggested, that unlike criminal sentencing and probation revocation hearing, the court goes back and the written judgment doesn't match the oral pronouncement. It's the written judgment that controls. So, you know, I assume the state's position is, by just writing paragraph 3, that written finding is what the court decided. My question would be, what if those could be internally inconsistent results? Does that affect that analysis? Is that something that is relevant to Judge Murphy's question? I mean, I guess what I'm saying is, could you violate all of that paragraph at one time based on the record here?
Well, what we have is the violation report that says that is what occurred and it seems to cite the same date for each violation. So I think that, you know, that where if the oral findings are any inconsistent with the written findings, the written findings will govern, except that we would note that where the court checked off that each violation would be sufficient for the court, that for the court should violate for each violation, we would, you know, if this court finds that that is error, we would argue that that's harmless error, as in State v. Braswell. You know, the court looked at, or the trial court looked at an incorrect allegation of violation, but the Supreme Court found that there was sufficient evidence to show violation or the basis for the actual revocation. So that's the state's position on any inconsistencies in between the written findings and the oral findings.
Let me ask a question about how we interpret the Jones case. Which parts of Jones would you consider to be holdings versus dicta? Would the state's position be as a holding versus just dicta?
I had actually considered that question before today, but I think that the holding in Jones, as we've argued in our brief, is that if the state has presented competent evidence and the defendant has not presented competent evidence, this can constitute a waiver, and that would be our position as the holding, that if the defendant did not compel the witness and request you know, that the trial court subpoena them, it may constitute a waiver. It doesn't say it must, but it may. And in Bryant and Morgan, for example, the Supreme Court looked at, in both cases, the Supreme Court found that that the trial court did not make the necessary findings and therefore did not have jurisdiction to hold the revocation hearings. But the result in the cases were different. In Bryant, the court did look at they looked at the record and said, there's no need to remand this because there's nothing in the record from which the trial court could, you know, make findings. In Morgan, it did remand to the Court of Appeals for remand to the trial court for further findings, because it said it could not say for you know, with certainty that there were that there was nothing in the record from which the trial court could make findings. So I think that, you know, this court can look at the record and make inferences if they exist in the record. I mean, you can't make anything up whole cloth, obviously, but you can look at the record, the trial court's explanation for why they did not view this as a confrontation issue. And this case is not like Coltrane or McCaster, where, you know, there was no revocation hearing or no proper notice given to the defendant. This case is quite distinguishable from that. The counsel was present. Defendant was present with counsel. They had an opportunity to cross-examine Lieutenant Thompson. They learned about the identity of the confidential informant. And they could have, if they wanted, thought that she would be a beneficial witness, could have called her or asked the court to subpoena her.
But confrontation has nothing to do with whether somebody's beneficial to you or not. It's about your right to actually confront the person that's saying something about you.
Well, again, the defendant had an opportunity to cross-examine Lieutenant Thompson. And
but I could tell you this whole story if I was called as a witness, now having read the transcript as many times as I do, but that doesn't make it competent evidence. That doesn't make me a useful witness. I could tell you what this confidential informant said. But why would that be of any use? Why would anybody get anything out of confronting me about that? All I'd be able to say is this person said that on that day.
Well, Lieutenant Thompson said a lot more than that. He said that he had, arranged, organized and supervised these drug buys. The defendant was the target of these drug buys, and that he met with the confidential informant, provided her with bills whose serial numbers had been recorded, and she told him after the drug buys, during the debriefing session, she said she bought the powder and the crack from Big Gerald, the defendant.
But people lie all the time. That's the whole point of confrontation. People lie every day. That's why we have confrontation.
Well, there was no indication that the trial court thought Lieutenant Thompson was lying or that his testimony was unreliable. So Lieutenant Thompson is a seasoned law enforcement officer.
Not as the lieutenant, but the confidential informant. I mean, there's no reason to believe this person was truthful, and that's the whole point of the protection that the Constitution gives. Is it not, or do you think, or is it the state's position that the 14th due process confrontation rights is somehow weaker than the 6th Amendment confrontation right?
Well, I wouldn't say weaker, but limited by the trial court's finding of good cause. And as to the veracity of the confidential informant, we are relying on Lieutenant Thompson's ability to ensure that he was sworn, he provided sworn testimony that this is what the confidential informant told him. We can read into that he believed her, that he found her credible.
But the lieutenant's not a finder of fact. The lieutenant's not the one that gets to make the decision. It's the elected or appointed judge that's to judge the credibility in these situations, not the lieutenant and what he thinks of somebody's credibility.
Well, the trial court was reasonably satisfied with the competent evidence presented by the state as a whole. And its burden, and that the trial court properly admitted the testimony of Lieutenant Thompson with regard to the statements made by the confidential informant. Unless you have other questions on that issue, Your Honor, I'll just quickly touch with the minute left I have on that second issue, whether the trial court lacked jurisdiction to revoke defendant's probation. In defendant's brief, he says that the trial court revoked his probation for testing positive for cocaine. The state would argue that again, as discussed, that the written findings would govern, and that the defendant did receive proper notice about the state's intention to revoke his probation. When the violation reports are all signed by defendant, where he acknowledges receipt, and they provide the date, and they provide the acts that he's accused of, the effects that those acts, if proven, would have on his probation, the state's intention to revoke his probation, and allowed him an opportunity to gather evidence and prepare a defense. And we would argue that the trial court did not err in revoking his probation on the basis of committing new crimes. And for these reasons, and those stated in the state's brief, we would ask this court to uphold the trial court's revocation, unless you have other questions, Your Honor. We would ask that this court uphold the trial court's revocation and find there was no error in this case.
All right, thank you, counsel. Any rebuttal?
Sorry, I had to unmute there. Yes, Your Honors, I do have a couple things I wanted to address. One was the state's claim that the good cause finding could be inferred from the record. I don't see anything in the record here that would allow that inference. If I had been able to infer a good cause finding, I probably would have attacked that on appeal. But when you allow a court, if you would uphold this on the inference argument, it would make it very difficult for appellate lawyers to litigate this particular issue. We need to know the contours of good cause and understand what the facts are that substantiate that in order to raise these issues on appeal. The second thing I wanted to address was Judge Dietz and this paragraph 3, the omnibus paragraph that had multiple violations. I don't think it matters if you address the 2 specific findings orally or you look at the entire paragraph, because if you look at all the allegations in the paragraph, they're all essentially the same as the 2 that were found. They're all possession or selling of cocaine. There's an allegation here there was a conspiracy to traffic in cocaine, although there's no evidence of any third person, I guess, that's trafficking or conspiring to do it. And then, of course, as Judge Murphy pointed out, there's this inconsistent allegation that it wasn't, in fact, cocaine, but it was counterfeit cocaine. And so I think if you look at all of those, you'll see that there was a failure of competent evidence as to each and every one of those claims. Although I would argue that where there's an ambiguity between an omnibus finding like this and very specific factual findings made by the trial court at the hearing, it's the oral pronouncement that would govern. I would, Judge Tyson did mention the marijuana, and I just wanted to point out that actually the judge dismissed that violation, so he could not have been revoked for the marijuana. But even assuming there was evidence to support that, it was less than 1/2 ounce, and it would have been a class 3 misdemeanor, which would have been non-revocable under the Justice Reinvestment Act. So I don't think the marijuana is an issue here because that violation was dismissed. But assuming it was an issue, it would be a non-revocable one. So I think those are the rebuttal things that I wanted to mention. And we would just ask in a conclusion that this the judgment revoking probation be reversed.
Mr. Yoder, let me ask you one question you may or may not be aware. Do you know what the current procedural status of Jones is? I do know that I saw that it was appealed to the Supreme Court. Has the Supreme Court made any ruling or set that for argument at all?
I can't actually answer that because I know the attorney is working on that. A petition for discretionary review has been filed in that case, and it's pending right now. The North Carolina Supreme Court will issue some decisions on petitions this Friday, the 25th, and it may decide it on that date. It may not. It's difficult to tell.
But they have not issued a PDR at this point, at least.
Well, they have not issued a ruling on that PDR yet. You're correct.
And are you aware if there's been any stay of that judgment or the mandate in that case issued by the Supreme Court?
I do not believe that a stay has been issued in that case yet. A temporary stay pending the decision on the PDR.
Thank you, sir.
Traditionally, a stay would not have been requested because it would not have, there was nothing to remand it for to the trial court. Typically, the appellate lawyer would request a stay to stop that from happening. But since the defendant in Jones lost, and the lower court order was affirmed, there wasn't a risk that it would have gone, the mandate would have issued and something would have happened below. So there was no stay, I think, issued in that case. But I will look, and if I'm wrong, I will send a memorandum of additional authority to the court.
Thank you, sir. I appreciate that.
All right. Thank you, counsel, and thank you to the parties for being willing to engage in this video oral argument. I know it can be difficult at times, but thank you both. Mr. Soar?
This session of the North Carolina Court of Appeals is now adjourned.
All right, we'll stop the recording so you're free to drop off at any time. Thank you.